we've got another presentation awaiting us.
Thank you so much. Let me do so. Who can share? Who's done? Okay. This platform. Okay, I'm trying to share.
Share the screen.
Yes, and it's just giving me a bit of a lag. I'm not sure why it is not allowing me to share. Okay, it goes.
Master Mkiza, can you assist so long? We have the presentation.
I should be fine now, Chair. I'm just checking if you can see my screen.
Master Mkiza is going to share. It's fine.
Okay, no problem.
Members also have received the presentation.
Thank you so much.
Can you fly it, Mr. Mkize?
Yes, thank you so much.
Thank you. Can you just put it in a slideshow? Slideshow. Slideshow there, Mr. Mkize, at the top. There we go. But I believe members are going through. There we go. There we go. Thank you very much. Member Becky, you can proceed.
Yes. Thank you so much, Chair, once again. As I said, I'm representing the Gauteng Provincial Office of the SAHRC, which is where the investigation into this matter or where the complaint was received. Please proceed to the next slide. I think you've missed number 2. Slide number 2, Chair, speaks to the mandate of the South African Human Rights Commission as derived from Section 184 and 181 of the Constitution. The relevant provision which is relevant for this presentation is that the Commission is mandated to protect, develop, and see to the attainment of human rights. But most importantly, we must take steps to secure appropriate redress where human rights have been violated, and that is point number 3 on this slide. Please proceed to the next slide. So where this investigation or where our mandate came from to conduct this investigation came from the SAHRC Act, as well as our CHP, which is our complaints handling procedure. In terms of Section 13.3 and 13.4 of the SAHRC Act, we must investigate. We can investigate in our own regard or when we have received a complaint. And in this context, we did receive a complaint. And then following that complaint, we also, in terms of Section 13.4, organs of state must afford the Commission such assistance as may be reasonably required for the effective exercising of its powers and performance. And that is what we, using that mandate, is what we utilized in order to get responses from other applicable departments. The next slide, please. So the complaint handling procedure outlines what it is that we can do. Obviously, we can investigate, we can subpoena, we can conduct mediations, we can refer matters to the court, and then we can also litigate in our own accord or on behalf of a complainant. Thank you. Next slide. So the legislative framework regarding this liquidation, I think, has been thoroughly covered by my colleagues earlier on as it relates to the Insolvency Act, the process, and where, in terms of the outline, the complainants who were the employees who came to the Commission where they sit in terms of this process. So just to show that when a company is insolvent, then what is the impact of the provisional liquidation order versus what is the impact of the final liquidation order? And I think the liquidators are going to go into a lot more detail for the of this aspect. And I think, Chair, if I can just leave that part to them to explain the legal framework so that I don't have to do that and I deal with the complaint as we received it. Next slide, please. This is the same as well. Next slide, please. Slide number 8. So, Chair, we received the complaint on the 25th of August, 2020. The complainant was Ms. Sekho Kekana on behalf of the employees of SAX. She indicated that this is she is an employee and that they had what they wanted, or they requested the commission to assist them in getting their salaries, payment for overtime, leave pay, and retrenchment benefits, all which were due to them as employees of SAX at the time. As outlined in the previous presentation, as will be outlined in the next presentation, by this, in terms of timeline, the provisional order was already in place. Please, next slide. The steps that were taken by the commission is that we registered the complaint. Similar to the presenter before, we wanted to obviously assist the complainants in this case to see if they can get a part of this of monies that were due to them by lobbying or by engaging with members of the following departments. That is the Minister of Public Enterprises at the time, the Minister of Finance, the Minister of Employment and Labor, and that is where we addressed the allegations to by the commission. We indicated that we would want to engage with all of the departments at the same time through a mediatory process based on what the complainants had sought, and to determine if the state, if I can put it that way, if the state would be able to make payments to these employees outside of the process, which was currently ongoing in court at this time. We did issue correspondence to DPE as well as to the employee representatives. As we said earlier on, Chair, there were 690 people who were affected, 691 people who were affected. And these people employees or were employees of SAX, but represented different aspects of SAX, but were employees nonetheless. DPE initially indicated that National Treasury's participation was required before financial commitments could be considered. We then issued correspondence again to those 3 departments, as well to the liquidators and employee representatives, asking all of us to come in and sit together and determine if there was a way to aid the employees. We received a response from Treasury indicating that the matter was an employee-employer regarded an employee and employer relationship, and they declined their involvement. We then issued further correspondence asking Treasury to still send a representative to attend to the mediation. We then, they declined again. We then, the DPE indicated to the commission that they had prepared a legal opinion, or they were in the process of preparing a legal opinion, which would guide them as to whether they would be able to aid the employees outside of the court process. The commission also you will see, Chair also commenced and got an opinion from SC as well, when DPE said that they also had an opinion, which they had also sought to also see if the legal framework does permit this to happen, and if so, how so. Our opinion we obtained from senior counsel, Advocate Poswa, who provided us with our legal opinion as the commission. There was, at some point during this liquidation process, and the liquidators will go into more details, where it seemed that there was a person or a company that was willing to come forward and purchase SAX and acquire it. So we were made aware of this around August 2020, around February 2021, but nonetheless, we still proceeded with the legal opinion. And what we established from the legal opinion is that obviously SAX is a separate juristic entity. Government is not automatically liable. Claims must proceed through the liquidation process, which was, as I said in the, earlier on, was already before the courts, and a provisional order had already been granted by the High Court. We were also advised that because the matter is sub judice and before the courts, obviously the commission cannot override what is currently before the courts. We still, though, proceeded to engage with DPE. We also then, not just the Department of Public Enterprises, we also, at all of these places of engagement, were with the employee representative, which was NUMSA at the time. And then we also engaged, NUMSA was participating at all of the engagements that we had. We also had another engagement between the Commission, NUMSA, and we attempted to also get the position of the liquidators, which they were able to provide in writing that, you know, this is also subject to the courts. Nothing can be done outside of these processes. We convened a mediation in April 2022. Next slide, please. And then 2 other attempts were made at trying to get all of the parties together. There was also a one-day inquiry which was convened where though the representatives were there and there were presentations that were made by DPE, not Treasury, but also by all of the parties where they indicated what the challenges were being. The High Court order came out in the final liquidation order was presented in 2022, which obviously now barred any other intervention. As will be seen, Chair, on what the outline is in terms of the act of where the employees stand as creditors, they are not necessarily at the top in terms of who will be paid when we have instances when a liquidation does take place. And at all material times in our engagements with the complainants, we did provide them with the legal opinion, and they were aware that this is what would be the challenge, is that once the order comes out, it does stall us in terms of any other intervention. And our intervention was really to try and aid the complainants outside of the court process through lobbying or through engagements with the department to say that there are these group of employees who, in essence, we can say are victims of everything that is currently going on with the liquidation of this SOE. Is there any way that they can be provided with part payment or any level of payment for monies that are due to them as employees? And as we said previously, that we wrote, and some departments did come forward to come and explain the opinion by DPE, similar to the opinion that we received. The commission indicated what the challenges of that would be, But nonetheless, we still persisted as the commission to try and to get the aid or to try and get assistance for the employees. We also then had, as I said, indicating in bullet 2, that we had engagements, many with NUMSA, the Pilots Association, the cabin crew. We were also vast representatives of the employees, and they were able to form a committee, which was the committee that we spoke to and provided communication to. There were about 5 or 6 members, and they were responsible to provide information to all of the representatives, all of the employees on behalf of the commission. As you know, it would be quite difficult to provide and manage 691 people at that level. But what we said is that they must just elect a few people, and those are the people we would direct correspondence to, and then they would send that correspondence up to the employees, and they were invited and participated in all of the engagements that we had as part of resolving this complaint. We also then, as I spoke about the legal opinion, but in the end, from the commission side, the mediation failed, mainly because once the final order was granted, the liquidation process has to commence as outlined by the courts. Thank you, Chair. I think that is the end of my presentation.
Ma'am Becky, thank you so much for that presentation. We really appreciate it. I will just request you not to leave the platform. The honorable members would like to engage with your presentation and take questions or comments. We members will deal with the last presentation from the stakeholder, which are the liquidators. Mr. Mkize, can you just also allow them to present and then introduce themselves? Please, representative, just introduce yourself, what role you are playing, and take us through your presentations. I'm giving you about 15 to 20 minutes to go through your presentations. Over to you, to the liquidators.
Good morning, Chairperson. My name is Aviwe Gyamaga, and I represent the jointly appointed liquidators of SA Express. I just want to confirm if you can see my screen.
We can see your screen. Can you just make it maybe also a slide, as a slideshow? Yes. I think it's clear. Members, are you able to see? From my side, I can see. You may proceed, Mr. Gyamaga.
Thank you, Chair. Chair, as fully described by the joint business rescue practitioners that were in office for 50 days prior to our appointment, the SA Express company was trading under insolvent circumstances for quite a number of years. And the main challenge that led to its ultimate final liquidation was the attempt of procuring post-commencement finance to enable the company to trade out, not just only during the business rescue proceedings.
Mr. Gyamaga, are you still there?
But to that, the company was. I'm here, Chairperson. Can you hear me?
Yes. Maybe you can just switch off your video for bandwidth purposes, because we tend to lose you for a few minutes. Maybe you can just switch off. There we go. And then you can just speak on the presentation. You may proceed.
Thank you, Chairperson. Yeah, so I was just giving a bit of a background in terms of our view as to the solvency position of SA Express, and our conclusion is that from the administration of the liquidation was that SA Express for many years traded under insolvent circumstances. It was not well capitalized to to sufficiently trade to meet its obligation. Hence, it found itself in a position where it was in rescue, and ultimately it was in final liquidation. Now, for purposes of just giving context about our role as joint liquidators, which is quite different from the role of business rescue practitioners, we governed by the Companies Act of 1973 as amended in terms of how we conduct our administration of insolvent estates, the Insolvency Act of 24 of 1936, and we are supervised by the Office of the Master of the High Court. The Office of the Master of the High Court appoints liquidators and administers, supervises the administration of liquidators. And the file number is opened at the Johannesburg Master's Office, and I attest that file number. The provisional liquidation was granted on the 28th of April of 2020. Now, there's been a number of engagements that we had, Chairperson, between ourselves as joint liquidators and at the time the Department of Public Enterprises, where we engaged in a number of ongoing milestones to try and preserve value and ultimately try and sell the airline in order for the benefit of all creditors, which includes the benefit to the employees. We have now finalized, we've done our administration, have almost 90% concluded the administration. We launched the first and final liquidation and distribution account, which was launched with the Master of the High Court last year. The account was advertised publicly. The estate, the administration has been substantially administered, and distributions structured as per the Insolvency Act in terms of the preference. The movable assets and other assets have been realized. We've recovered some debt collections, and there's been a free residue of about 3.7 million rand that was payable to the creditors. Of course, legal and professional fees have been paid, asset valuation, preservation costs, debt collection costs, storage, etc., and the master's fees. All of these have been fully described in the liquidation and distribution account. The creditor rankings, secured creditors are paid first. Then there's a preference portion where employees benefit from. We have a list of, I think, about 55 employees that we still need to pay dividends to their preference portions. We are now currently tracing that. That's one of the items that's outstanding. There's approximately about 2.99 million reflected for a preference payment to these particular employees. Employees are recognized as preference creditors. Majority processed in terms of the statutory claims. Claims are reflected in the large distribution account. What is outstanding, Chair, as we sit today, the 55 employees remain unpaid. We're currently tracing those employees. We have an amount of 4,500. That's a preference portion. That's outstanding to the employees. We're looking at about 250,000 rand. That's available for payment towards the employees. And we're tracking those employees. The other item that's outstanding is a sale in the region of about 150,000 rand, purely looking at the brand or the intellectual property as a residual asset. Transaction is not yet finalized. We're not quite certain when we will conclude this transaction, but the two main things outstanding until we finalize the ultimate liquidation is the payment of the employees and the disposal of the intangible assets. So to conclude, final liquidation account lodged with the master. Estate has substantially been wound up. Limited outstanding employee payments are outstanding. Brand sale pending. And then we are approaching the finality of the liquidation administration. Thank you, Chairperson.
Thank you very much, Mr. Yamaha, for that input. Also, my request to yourself, is to stay on put as we proceed with this session. Honorable members, that is now 11:12. We've received 3 inputs, as I indicated before. We've received input from the Human Rights Commission. We received inputs from the business practitioners. We also received input from the liquidators. And there is the information before us. I'm going to allow members to engage with the presentations as we're dealing with the petition of the former employees of Ace Express. I've got also a number of questions, but I'm going to first open the floor for members to engage with the 3 presentations. Honorable members, just raise your hand. I'm noting Honorable Mananiso. Honorable Mananiso. I see on the hand of Honorable Mananiso for now. In that order, I'm going to give over to Honorable Mananiso for her input. And Honorable Pala. Honorable Pala.
Recording in progress.
Honorable Enowe. Yeah. Honorable Mananiso, Honorable Pala, Honorable Noe, Honorable Billy. I also note you. Yes, I've got 1, 2, 3, 4. Honorable Mananiso, you can take the bite first. Over to you. And Honorable Chief, our whip of the committee, Honorable Nkosi, you will be the last one. Okay, over to you, Honorable Mananiso.
Yes, thank you, Chairperson, and all the members online. And Chair, let me start by appreciating the presentations that were before us, noting that
Honorable Mananiso, my humble apologies. Remember, we didn't do the introductions earlier on. You can also utilize the opportunity for that introduction. I did not introduce members earlier on individually. I did say we'll introduce as we go forward. Over to you. You can just include that.
Okay, thank
My
you,
apologies.
Chairperson. Thank you, Chairperson. Chairperson and members on the call, I'm Honorable James Buleti, the member of the Select Committee, Petition and Undertakings. Chair, as I said, let me start by appreciating all the presentations that came before us and as well appreciate how simplified were they in terms of understanding what needs to happen. I don't have questions for the first presentation and the second presentation of the human rights. My question is with regards to the SA Express, a presentation that was made by Mr. Nyamara on issues of what has been presented. And I've noted that on other matters, he was very clear why there's liquidation. So mine is just to check if the entity has a program of action in terms of the timeframes on the process of disposal of the asset and the payment of employees. Because for me, that's what one feels that I'm interested on, because you can tell that the issue here is about an insolvent capacitation of an institution. So there's no need of holding to something that is no longer working for what was meant. So I just want to know if they have a time frame specific program of action that we can monitor and evaluate as we do our oversight and accountability. If what will be presented to us is what they would be doing in terms of ensuring that they resolve this matter to their intent. So that was only my question that I wanted to get from him. And thank you, Chairperson.
Thank you very much, Honorable Mananiso. Thank you very much for those inputs. I hope Mr. Jamaha, you noted those. My next on the list is Honorable Pala. Over to you.
Thank you, Chair, and good morning, honored members, and good morning to the presenters, and thank you for your presentations. Yeah, it's very clear that in terms of all your presentations, there were an attempt to try to save to rescue the entity, but due to, I think, the situation beyond your control, you are unable. And one thing which you don't mention here is that this thing happened during the COVID, the most difficult time of our in our country and the world. Chair, I was going to propose that you reminded us about the key issues which were submitted by the petitioner, just to see what, just to remind us. I think the petitioner did present to us some time back, but just to remind us about the key issues which the petitioner was complaining about. I just wanted to remind us so that we compare with what is presented here. Thank you very much.
Thank you, Honorable Pala. I'm gonna just give to the members now, and then I can just give a brief in terms of that. Honorable Noe, over to you.
Thank you, Chair. I'm using a device which doesn't take the Parliament background. Thank you. Good morning, honorable members and all the institutions that have joined us and have just made a presentation this morning. Chair, for me, it is really clear, as Honorable Pala said, that all what could have been done was done and followed accordingly to deal with this matter. My question, it relates to the presentation of the human rights. I just wanted to establish at the very end presentation, the colleague mentioned that they did make an attempt or to advise the employees that it could have been best if they would have made an attempt to settle before the court ruling. So I just wanted to check whether did that happen, and what was the response from the employees regarding their advice, having analyzed the situation as it were. Thank you very much.
Thank you, Honorable Noe. Next is Honorable Billy. Over to you, Honorable Billy.
Chair, I'm really battling with my connection. I'm in the rural part of KZN. I'm not sure if I'm audible.
We can hear you. We can proceed.
With your permission, can I keep the video off so that I can at least try and make this point quickly?
Granted.
Thank you. Chair, my name is Mzamo Billy. I am a permanent delegate to the NCOP representing the province of KwaZulu-Natal. Maybe let me start by joining my colleagues in appreciating the presentations which have been brought to the committee as we continue to embark on this process. Chairperson, I think we would agree that this matter raises, at least for me, two key questions. Whether the liquidation process maximized justice for the workers. And the second part to it is whether our constitutional institutions have done justice or have gone far enough to protect the same workers. So maybe let me start with the directed to the liquidator.
Please, stakeholders, if you're not on the platform, can you mute and also close your camera, please? Unless I've given the opportunity to speak, can all of us please mute and switch off our cameras? Apologies, Honorable Billy, you can proceed.
Thank you, Chair. So maybe to the liquidator, I just want to check of the approximately 691 employees who lodged claims. I want to check what percentage of the total claimed amount was actually paid, and how many received less than half of what they were owed. Because I think that it's important for the committee to get clarity on the real recovery, not just the procedural ranking that was outlined. And secondly, Chair, I want to pose a question. What is the total value of legal and professional fees paid from the estate, and how does that compare to what employees received? Because you would know that in a state-owned entity collapses, we must at least ensure that professionals are not better protected than your normal workers. And the last question to the liquidator: did you pursue any recovery action against former directors or management for reckless trading or irregular conduct? And if that was not done, can you inform the committee as to why? Because every lawful avenue, in my view, should have been explored to maximize returns for the employees, especially the workers. My second part to this, Chair, directed to the Commission. And when mediation failed and insolvency constraints were confirmed, can you inform the committee if the Commission considered any litigation or at least constitutional challenge to test whether insolvency law adequately protects socioeconomic rights in SOE failures? Linked to that is, given that SA Express was state-owned, did the Commission interrogate whether the state bears a constitutional obligation beyond corporate personality principles? And finally, Chair, would the Commission recommend any legislative reform to strengthen worker protection in future SOE liquidations? Chairperson.
Mr. Alpheus, please switch off your camera. Otherwise, I'm going to take you out of this meeting. Can you please mute? If you're not on the platform, please mute your microphone. As well as Ndate Sibanda, Tulasi Sibanda, switch off your camera and mute yourself.
Chairperson,
My apologies, Honorable. You can proceed.
As I conclude, Chair, I want to maybe put it to you, Chair, that compliance with insolvency law may conclude a process, but it certainly does not automatically conclude justice. So perhaps this committee must ensure that in future state collapses, we do not see workers carrying the heaviest burden. And I think, this does give all the stakeholders an opportunity to seriously reflect and at least in terms of legislation, how is this dealt with going forward? Those are my questions, Chair. Thank you.
Thank you very much, Honorable Duly. We really appreciate your input and the honorable members. McQueen, can you switch off your camera, please? We're going to hand over now to Ndate Nonkonyana, which is our committee whip. Honorable Nonkonyana, over to you.
Chairperson and honorable members, good morning to you all, and those that have not met this year, compliments of the new season. My apologies again, Chair, of the background. I'm in the similar situation with Honorable Noah, and I am Muelo is my name, and Nongonyana is my surname. I am the provincial whip for the Eastern Cape province and also the whip of the committee chair. And I join the honorable members for thanking the presentation and thanking also you to convening this meeting and your introductory remarks in actually kickstarting this important engagement. Thank you so much. First, Chair, I am perturbed by the report that there is an element of reckless trading on the part of the board of directors that were entrusted with the affairs of this subsidiary of the state-owned enterprise. And like Honorable Billy, I don't get clear about the consequence management, whether there is, because I know in terms of the law, Companies Law Act, if you trade under reckless circumstances, the board are personally liable. I've not heard from the presenters whether there have been any pursuit around that, both from the rescue practitioners as well as liquidators. Any or both of them may then clarify me there. Secondly, Chair, I know in terms of the Insolvency Act that the liquidators are actually empowered in terms of that statute to go deeper and deeper and deeper to find even the little cent that should be there to pay the liquidators and any costs that may be occasioned about this. I hear that there's been what we call the rescue practitioners first. I heard that there was a joint practitioner, but I didn't hear the name of the joint rescue practitioner and the reason why there was any need to have joint practitioners. If I can be clarified, I'll be happy about that. And again, there is an issue which worried us before and which continue to worry us about why the relevant department did not oppose the provisional liquidation first and also participate in the rescue mission of this entity. And therefore, perhaps the liquidators could, I have heard that there is some engagement with them, but I have not got a clear reason why, in the first place, they did not want to be part of proceedings in the provisional liquidation, why they didn't oppose that or even participate with a view to really save this entity. And again, it is incidental to that issue of reckless trading, whether there is no recklessness on the part of the major shareholder, which is the relevant department in handling of this matter, which will therefore give us an opportunity to get clarity from them. Whether they are predecessors, doesn't matter to me because these people must be accountable for what actually had happened. And again, Chair, on the question of the employees here, their preference, their outstanding amount of money that are being owed to them, and I really appreciate that. But I don't get clear why some have been paid and others have not been paid, and whether is there any rationale for that discrimination, as it were, if I heard them clearly. If I didn't hear them clearly, clarity is being sought in that regard. And again, Chair, I don't know, but I know that you said you will also brief us perhaps later on this. The petitioners, and it would be good if we also receive from the petitioners themselves a response. Once these three have presented, at least we know what the comments of the petitioner, so that at the end of the day we will be able to weigh both sides of the story, as it were, with a view then to make a determination at the end and submit a report to our principals, the NCOP itself, with a view to deal with this matter. Otherwise, I want to thank the petitioner for bringing this to ourselves, and also the stakeholders that have made the presentation. I think it is valuable, but I would love, therefore, if they can just clarify us on the issues that we have asked, as well as the comments that we have made, with a view that at the end we do justice to the petition. With those few words, Chair, thank you so much. I appreciate it.
Thank you very much, Honorable Nonkonyana. Thank you very much for that incisive input, and to the honorable members. Please, to our stakeholders, we understand it's our meetings in Parliament and this democracy are open to the public, but I would really appreciate if you can just minimize interruptions, switch off your camera, switch off your mic, because otherwise it disrupts the proceedings. Honorable members, thank you so much for this inputs. And I know that our stakeholders are on board and to respond. Mine are actually just two, both to the Human Rights Commission as well as to the business practitioners, as well as Mr. Nyamaha from the liquidators. And I think Honorable Billy touched a bit on it, but I want to bring us also on another angle. To me, it seems as if the state is absolving itself from this process. And I'm having a bit of difficulty there. I'm saying the state in terms of National Treasury, Transport Department, the DPE, which has been now dissolved, is no longer the public enterprises and has been kind of absorbed into the presidency. I was just want to get your comment. I mean, this is from the three stakeholders. You know, my understanding is that even the name, it says South African Express State-Owned Company, LTD, or is it LTD Pty, something like that. But SOC stands for State-Owned Company. And at the heart of it, in my mind, the entity was still a baby of the state. Even though you have to work within the confines of the Companies Act and the shareholders and so forth. But ultimately, this was a baby of the state. I mean, for me, there's no way to beat about it. And I'm having difficulty when I'm picking up that the state, maybe as a major state shareholder, they're trying to absolve themselves from this process. I'm not a legal person. I might not understand the company's procedure and so forth. But as a layman, that is my area of concern. And I would like to get an input. And I know from you, Membeki, you did say that there were those engagements for Treasury to bring them on board. They said that, look, this is a matter between employer and employee. There was engagements with the DPE at the time. There was engagements with Transport Department. And ultimately, they removed themselves from the process. And for me, that is a area of concern. You can't ever state saying, no, look, we are out of this thing, we can't help. but it was a baby of the state. So maybe just to get an expression, and that can include all three stakeholders. And a specific one now goes to the Messenger Maha. In slide number 6 in your presentation, you are speaking about 55 employees. The petition that we've received as this committee, it speaks about 691 former employees, and they are specific. The gist of the matter, and I'm going to read. It says the salaries we worked for before the liquidation in question, which the government stole from us. This is now from what the petition told us. All our monies from the liquidation proceeds, as we are creditors to, by virtue of the salaries in question. All our standing monies from both the pension and provident funds. And the retrenchment package, which the government finally announced in Parliament back in June 2020, that will be given. It should be noted that some SA employees were given these retrenchment packages, but it seems these employees didn't receive theirs. And that is now the gist of what is happening. And I heard you speak about 55 employees. And it's also but said that you said, the company was deducting money from the employees, but did not pay to the third payer. So they will deduct money from the salaries in terms of pension contributions, but they wouldn't put it on the other side of where it should go, including the taxation. And for me, there's an area of concern. So those will be my two key issues in terms of the government's role. Honorable Billy also reflected in terms of constitutional obligations, but I just want to get my understanding there. And to the liquidators, a reflection that you speak about 55 employees, and also you are saying you are struggling to trace employees. It's a bit of an area of concern for me. When you were liquidating the company, I'm sure you were able to get the books of the company. You were able to get the human resources register or file that will be able to assist you to say who are the employees or who were the employees of the entity. So I would just like to get a reflection on that. And then to Honorable Paula, I think I sent a document to our WhatsApp group. I don't know, do you want to have a last bite before I give over to the responses? Honorable Paula? I tried maybe just to summarize what were the issues from the petition. I'm going to give to Honorable Noe, and then we're going to give the presenters to respond. Honorable Noe, over to you.
Thank you, Chair, for allowing me. It is just to add on the list that you just read, I just also browsed through the initial petition itself. There are two additional areas which perhaps we can establish from either business rescue or the liquidators, whether did they consider or venture into that. One, the petitioner indicated that they also wanted to be refunded by the money that they paid to PS Semenya attorneys, which is in the region of plus minus 70,000 according to the petition, but I don't know who will have processed that. Maybe they will want to comment on that. And also the refunds of the legal costs that they incurred as they were, of course, fighting for this case. Obviously, it relates to the Semenya attorneys. Thank you, Chair.
Thank you, Honorable Paula. I'm Honorable Noe, my apologies. I don't see Honorable Paula, do you want to have a bite?
Yes. Thank you. My initial concern was about the petitioner's request, whether all the presenters as they presented here, whether they have considered issues which were raised by the petitioners. So it is along what Honorable Noor has just asked now. If they can just indicate to us whether they did their best to deal with issues which were raised by the employees who were the most affected people. So that was my area of concern, Chair. Thank you.
No, thank you very much, Honorable Paula. Honorable members, thank you for those inputs and questions. I'm going to, I see Honorable Midupi. You haven't spoken. I'm going to again over to you. Introduce yourself and over to you, Ma'am Midupi. You can proceed. Midupi, you can unmute. Yes, we can hear you. We can proceed.
Can I proceed, Chair?
Yes, you may.
Oh, how on my gadget it shows that I'm still muted. Okay, thank you very much, Chair. Chairperson, mine is just straight to the point. One, Chairperson, let me acknowledge the presentations and also greet all members on the platform. But the question that I want to just establish, Honorable Chair, is that during the mediation process, it is clear that the mediation did not materialize, it did not work, it did not yield good results. But I'm just interested to know what were the issues that dispute, especially with the employees representatives, from the side of the employees representatives. And just another one is on the payment of the dividends. When are they anticipating to pay the 51 employees who are due for their dividends? Thank you very much, Chair.
Thank you very much, Honorable Midupi. Members, I think I've exhausted all the hands and all the inputs. We're going to go in this order. We're going to start with the very first presentation from the practitioners, Mr. Daniel and Ntate Mkombo. I hope you noted all those questions. I'm going to hand over to you, and then we're going to proceed to the Human Rights Commission, and then we'll conclude with the liquidators, Ntate Gyamaga. Over to you, Ntate Daniel. Mr. Daniel, are you still here with us?
Yeah, no. Honorable members, thank you. Just to get back to the questions that had reference to the business rescue proceedings, and Pathlani, if I miss anything, do not hesitate to interject. The question by Honorable Pala, I think it's important if you consider the report that we filed, the one of the 10th of March that we went through today, the reasons for the failure of SA Express, we dealt with that very clearly and quite comprehensively from paragraph 3.11.1.5, and that's on page 7, to page 16, and the paragraph number 3.11.1.6.5. I think it's important for your report perspective to perhaps, I don't want to say copy and paste, but to use that as the items that we've found in our preliminary investigations that caused the financial distress position within SA Express. I think it's also important to note that on day one, and this again refers back to our report, the insurance payment, well, in fact, the termination notice from the insurers in respect of the insurance was already in place. It was issued in December 2019, prior to the commencement of business rescue. So that was a material problem. We've also mentioned that at that stage, there was already a claim of circa 150 million from SARS for the non-payment of statutory deductions made by the company and not paid over on their behalf. And then the main reason for the failure of the business rescue proceedings, and again, this is nothing to do with the business rescue, with the reasons for the failure, is not having the ability to secure post-commencement funding from the shareholder, which is obviously the state or government. So we did everything we could to get the government to support by way of guarantees. We went to the financial or commercial banks to get support, and they weren't interested in accepting guarantees from government as security. And secondly, also the words by the the Treasury, confirming that SA Express only profitable for 4 years since the inception, and that's 1994. And they referred to SA Express as a notoriously inefficient operator. So that's why they weren't prepared to fund the business. So again, we can't debate anything what happened on their side. We can only give you the information that we've received from the respective parties. And then a very important question by Honourable Nonkunyana. Did the business rescue practitioners investigate any possible failures by the directors? The one downside of Chapter 6, the New Companies Act, is in fact that the business rescue practitioners cannot call for inquiries into the failure of businesses. So that's something that I think a lot of practitioners has already asked for, to put in our arsenal, to be able to actually do inquiries, to find out the reasons and to pursue any failures by any parties that might have been a reason for the failure of the business, or might have added to the reason for the failure, and that we didn't have. And that was something that a quiver that the liquidators have in their arsenal. And I think they did call for an inquiry. I think the liquidators can perhaps confirm that. Another question I think is very valid. SA Express is seen as a large entity. You calculate that on your public interest score, or a public company, and this is a public company. The fact that 2 practitioners were appointed is because it's not only a difficult engagement, but a very large concern. What I can confirm to the honourable members is, once you appoint it, the BRPs will then split the work. So there's no duplication of work in business rescue. Practitioners deal with different facets of the business activities or the engagement, and then we work together in respect of the process, the administrative process. Just want to see if there's anything else that I could find. Yeah, I think that those were the questions that was posed in respect of the practitioner's report. I think if there's anything else, Bethani, that I might have missed, I actually made notes, so I don't think I did. But if there's anything that I've missed, by all means, you could just add that. Thank you very much for the opportunity.
Thank you. Dr. Patlane, over to you. Is there anything that you want to add?
Thanks, Chair. I think the one question that was also asked was why the 2 departments did not oppose or participate in the rescue or in the liquidation proceedings. And I think we have demonstrated, Chair, through our report and through the letters that we sent to the 2 departments during our tenure as the then practitioners, that we wanted to engage them. We did try to reach out, but they were non-responsive to a certain extent, because I think, it was clear that this company was trading under liquidation circumstances, and the only way out was it needed to be funded by government, and therefore, one, to oppose the court application, one needed to put in funding to demonstrate that the company will then be able to come out or cure its distress or insolvency circumstances. So I guess, in my view, and unfortunately, they did not tell me or give me the reasons, but that's what we deduced from the way they were engaging with us. I think my colleague has dealt with the issue around reckless trading. Just to reaffirm, we as practitioners, we don't have the investigative powers like liquidators. We are mostly forward-looking, and the Act does provide that to the extent that there's reckless trading, there's any misappropriation, we have to refer the matter to the relevant legal authorities for further prosecution. But because this matter ended up with the liquidators, then that responsibility, ended up with the liquidators. So, from my understanding, is that the liquidators did commission an insolvency inquiry. They can confirm if that is the case and what the outcome of that process was. Thank you, Chair.
Thank you very much, Mr. Mkombo. Thank you for that information. Just from my side, it will be important that you forward that communication, and that also applies to the Human Rights Commission, that trail of communication between yourselves and the relevant departments, including your treasurer and so forth. It will assist just for me where I'm sitting when we deliberate and develop a report on this petition. We are able to satisfy ourselves that indeed, those consultations and interventions were in place. So maybe just through our Secretariat's office, finish us with that communication. Will that be doable?
Mr. Chairperson, sorry to interrupt. All the correspondence that was held with the respective parties as referred to by Bethlani was attached to the liquidation application. So you will note that we've circulated that to the Commission. If you look at there's a document stating what the contents of the attachments or annexes are. You will see exactly the letters and also the dates of the respective letters. So you've got it there all to review.
Thank you very much. Thank you very much, Mr. Trelbanch. We really appreciate your input. I'm going to again over to Ms. Becky from the Human Rights Commission to respond to some of the questions asked by members. Over to you, Ma'am Becky.
Thank you so much, Chair. And yes, I can send all of the correspondence, as well as I think a more detailed report from our end over and above the presentation. There was a question regarding Semenya attorneys. It could be confirmed, but Semenya, our engagement with Semenya attorneys came last year. Semenya attorneys, as far as I have a record on behalf of the Commission, is that they were asked by the petitioner to request information from the Commission. That information on behalf of the Commission was provided to Semenya attorneys. We were supposed to meet with Semenya attorneys. However, we could not settle on the meeting, but nonetheless, they provided us with a letter and outlined the information that they required from the Commission on behalf of their client, who is the petitioner. And that same information was provided to Semenya attorneys. Also, to note, Chair, I think also through another platform, the petitioner has also requested information from the Commission. The information has been provided directly to the petitioner, as well as through the different fora that the petitioner has requested information from the Commission. I believe that the petitioners were also part of the engagements that we had with the stakeholders, as it was an open meeting. Then it seems, let me just try to get some of the questions also, Chair. On the question of whether the state has been absolved from taking responsibility on the issue, I think what sort of limits the intervention is the legal framework. From our end, it was sort of like chasing a deadline when you knew that this order, once provided, would limit the level of engagement that we would have. There is no statutory duty, and I'm looking at our legal opinion, which Chair will also submit, that the statutory duty for DPE, particularly for Treasury, if you and I wanted to petition Treasury for any form of allocation, that process is guided and goes all the way out, all the way up to Parliament for Treasury to intervene and have an allocation which is outside of a budget of a particular department. That is what it would have required for Treasury to be able to intervene, and that is what Treasury at the time, through the Office of Mr. Godan provided to us. And that would require that this necessary level of lobbying on guidance that the department would have to undertake DPE in engagement with Treasury so that we could have an allocation for the employees. But it is much more clearer in the letter that we've received, and we will submit all of the correspondence, and it goes to much greater detail. I do agree with the fact that in the end, the people who suffer the most are the employees. One, at a lobbying level, as you would have heard from both presentations, that at a high level of engagement, you would find that the position or the chair for the employees is rather quite small in the discussions or in the negotiating table for any employees in a liquidation process. It was for this reason that we went as the commission to say who has been engaging on behalf of the employees, and I made mention of our engagements with NUMSA and NOMSA, the employee who at the time I'm not sure who's unmuted, who at the time also indicated that they had been participating or had been trying to get a chair around the table or through the negotiation at the negotiation table. But overall, when a liquidation process does take for business, maybe it might be better at a business rescue process versus a liquidation process, is that the negotiation or the contribution of the employers around the table or the chair is rather quite small based on the legal framework of the country. Then send the trail of email. So to answer the question of whether the legal framework does bring at the forefront worker protection, it does not. When we look at not just in the cases of SOEs, all of the companies that are liquidated ordinarily, but also during this time, as was said by the honourable member of COVID, that the workers do not get the share in the negotiating table, but also looking at how they are listed in terms of when the distributions are made and where they are in the list, we will see that they are really at a latter end. Yet they are the ones who, like in this case, were not participating in the conduct or were not part of the mismanagement. So in terms of the legal framework of the country, definitely this should have been or should be considered when we're looking at potentially amending legislation accordingly. We should also, I think, consider, and maybe the colleagues, the liquidators can confirm, saying that the workers hold better position during a business rescue process than a liquidation process. The liquidation process having been commenced by the creditors. I do not hold the position of being an expert on this subject, like the two colleagues who are presenting here. But the sense that, or the understanding that we have, is that at a business rescue process, there is a better, I want to say, if there are funds, a better negotiating position for employees, or a better position for employees, rather than at a liquidation process, which would have been commenced by the creditors. And the creditors after a liquidation process are obviously owed a great amount of money and get a high level of preference, as outlined in our presentation. So to distinguish between a business rescue process versus a liquidation process, and also providing the position and outlining what the position is for an employee in that context, it would be better that, when a business rescue process is undertaken, that considerable effort be placed under that than when there is a recommendation for liquidation. Whether there's a constitutional challenge to the act, I would have to draw up an opinion on that. But I can definitely, I think it was Honorable, I think Billy, who asked the question. I might have the wrong name, Chair, but there was a question on whether this act actually does infringe on constitutional rights, and we would be able to one would have to make that assessment, because in this context, as I said earlier on, you've got creditors who are owed funds by an entity, including in this case employees who are also owed funds, by the entity. Now, in a case like this SOE, we would find that the amount that is owed to what was external creditors who are providing services to the entity versus the amount that was owed to the employees, maybe those amounts are not equal at all. But definitely, when one looks at it in a literal sense, you work and you're entitled to pay. And therefore, if you are not paid for your work, that person, as your employer, is violating your labor rights. So it's very clear that even under a labor rights lens, the LRA and the basic conditions, if you have been working, you must be paid for the work that you have done. This now shifts within the context that we're talking of now, when we're talking in the liquidation sense, guided by statute that says that now wants to list how creditors are paid, and then also looking at the fact that there is now a pool of money, and from that pool of money we must have apportionment. It was for that reason that we said as a commission, maybe employees cannot, that's why we wanted to say, can we look at a process outside of this business rescue process to see if there is a duty or if there is any form of funding through DPE, through Treasury, that could make a mechanism available to pay these employees, noting obviously that they did not create these circumstances. Also, we must note at the same time, there were discussions to provide aid, and a lot of aid, to SAA, which we see now fully functional. The two were the two SOEs, which were in discussion quite a bit at that point, and we were jumping on that bandwagon, if we can put it that way, to say that if we are considering aiding SAA and all of these, all of its entities, could we also have consideration for SAX employees under a similar or under the same framework, so that they could get their level of apportionment? But it must be clear that we understood that in terms of the legislative framework, we were sort of very tight, and that's why we were going through this level of engagement, relying on what was going on at that time to see if we could get some apportionment for the employees through a treasury allocation. So to answer the question, yes, the labor rights, when we look at it in a sense, when we look at it as payment for work and work for payment, the rights of the employees have been violated. There's just some confusion. I don't know, the first question, I think misunderstood what we said, that the employees should try to settle before a court process is undertaken. That is not necessarily the position that we had. I'm not sure who had said, maybe made that presentation, but it's not something that we submitted, Chair. What we said was that the final or the final order, which would come from the court, would stop and would commence a full liquidation process, which would require engagement with the liquidator. And therefore, between the process of the provisional liquidation and the final liquidation being granted, and all of the interventions that were being put in place, including that of people trying to, or other companies trying to buy the SOE. That is when we had room to try and engage in that. The order would sort of stall us, because they are then would stop us, because there are then other creditors that are also part and parcel of this liquidation process. I guess, Chair, in summary, we were trying to aid the employees, the mediation, and trying to get all of the parties together. All of the parties did make their submissions as to why they can and why they cannot aid, either because the matter is sub judice or because it would require a treasury allocation. Thank you so much, Chair.
Thank you so much, Ma'am Becky. We really appreciate that. Was a comprehensive response. Can I just make this a plea once again to the former employees? I know this is a very sensitive and emotive issue for you. However, this meeting is for the members of the select committee as well as the stakeholders. I would appreciate if you can just switch off your cameras as well as and mute. And I'm specifically now referring to Mr. Jacobs Peters and Mr. Faisal Makata. Just switch off your cameras. You are on this platform as observers, and your camera video, if it's on, is a distraction, including Me Kilebogile, Mona Motsani. Please switch off your video. Thank you very much. No, we really appreciate those inputs, Ma'am Becky, for that responses, and we know it. Members, I will gonna give now to the Mr. Avian Damaga, who will then give his input as the liquidator. Over to you, Mr. Damaga.
Thank you, Chairperson. Chairperson, I will not switch on my camera, I think due to my bandwidth issues. Is that fine with you, Chair?
No, that's fine. You can proceed. We saw you earlier on.
So, Chairperson, the first question I noted came from Honorable Mangaliso, and this related to the employees and the timing of payment and or finalization of the estate. Now, if we could trace the 55 employees and when we say trace, Chair, I'm talking in respect of FICA documents, bank confirmation letters. We need to receive that so that we are then in a position to immediately pay the preferent portion of the employee dividend. To clarify, the total claims that we've received from employees is in the amount of 665 employees. So they've submitted claims for what is outstanding, which includes retrenchment packages, salaries outstanding, etc. However, the liquidation and distribution account, because of what has been recovered in the liquidation and in terms of the Insolvency Act, the employees' dividend portion or preferent portion only amounts to a total of 2.9 million rand. And if you look, and the preferent portion for each employee is in the amount of 4,520.29 cents. So out of the 665 employees that have submitted claims, we've already made payment to 610 of those employees of the preferent portion in the amount of 4,520.29 cents. Only 55 are outstanding. What are we doing about that? We've managed, yes, as much as I agree, Chairperson, we have the books and records of the company, but these are old documents. And in that, we don't have necessarily all the contact information. We have old contact information, but we've managed to, there's a volunteer, a lady by the name of Lerato from Signia Group, Youth Employment Service, who's assisting us at no cost at all to trace the 55 outstanding payments, outstanding employees, bank confirmation details in respect of FICA. That then allows us as liquidators to be in a position to pay the dividend portion of 4,520, which amounts to the preferred portion as provided for in the Insolvency Act. So that's one question in relation to the employees. Secondly, what is the timing in finalizing the estate? The outstanding, if we can resolve the outstanding items within the 2-month period, that's one outstanding. If we can resolve the sale of the intangible item, which is the name and the brand, within a 2-month period, then the estate will be finalized by April 2026. However, if we are not successful in tracing these 55 employees, we'll then have no alternative as the joint liquidators, but then to pay those portions into the Guardian's Fund and still finalize the liquidation. So to answer that question, by April 2026, we will have finalized the estate administration. The second question coming from Honorable Billy. Honorable Billy, I understand your question to be as follows. What legal fees have been spent to date versus the dividends that have been paid to the employees? Total legal fees spent to date is in the amount of 7.8 million rand, and the total dividends to the employees, the preferred portion, is in the amount of 2.9 million, as I had said previously. And that is in terms of the Insolvency Act. The 7.8 million that is clearly and specifically specified in the liquidation and distribution account, which, Chairperson, I think I should share that distribution account with details, what are the expenses, what they were incurred for. But largely, we as the joint liquidators convened what is called a Section 417, 418 inquiry, which then dealt with the investigation into, one, recoveries of debtors, two, any possible gross negligence or reckless trading against the directors. We instituted those proceedings, and there's a report that stipulates the possible claims that can still be pursued against the directors. I'll just have to get a go-ahead from the legal team for me to share that report. So what does it confirm? It says, in our view, and based on the investigation, there was gross negligence indeed by the former directors, and they can be pursued for personal liability to recover, but that comes at a cost. And the estate does not have sufficient funds to pursue those claims against those directors. And that's a consideration. We cannot spend creditor funds money in totality for a pursuit of a probable claim, because naturally these directors will oppose these actions, and it takes time and it's expensive. So as joint liquidators, at some point we have to draw the line. We've been appointed in 2020. We're sitting in 2026. We have an obligation to finalize the estate in the interest of all affected persons. The comparison, so 92% of all employees that submitted claims have been paid a preferred dividend portion, and the other 55 or the 8% is the ones that we are currently tracing. So to answer that question, it's 7.8 million, yes, that has been spent, and then there's 2.9 million that has the benefit in respect of the employees. To answer the other question, Chairperson, from Honorable Mvelo Noganyana, yes, the Section 418, 417 inquiry has been conducted, and we have found that indeed there's probable claims of a possibility of gross negligence against the directors. However, that requires funds to be pursued and to pursue those claims, and there's just no guarantee or probability from a prospect perspective that there will be tangible recovery for creditors, and there's just no ways that we can estimate how long that will take for us to pursue those claims against the directors in regard to the reckless trading. Thank you, Chairperson.
Thank you very much, Ntate Jamaga, for that input and responses. Honorable members, we've exhausted the three stakeholders in terms of the responses from their presentations. I still have a bit of inputs, but we will deal with it. I'm going to request for the last time. I understand and I sincerely share in your frustration to the former employees who are affected in this petition. You are welcome to observe the meeting. It's an open meeting of Parliament. Parliamentary meetings are open to the public, but I request that you just switch off your videos, and you are only on observer in this platform. So desist from sending message on the chat box. We have all the information. We have been thoroughly briefed on this presentation and this petition. So we have your issues we're having in front of us. So we're just trying to get to the bottom of the issues. So just refrain from that. It just disturbs the proceedings. The people who are going to be afforded opportunity are the stakeholders. So I'm just asking that we just switch off our cameras and our microphones. The meeting is open for the public, but you are on as observers. Honorable members, I'm just taking the last round. I see Honorable Billy for a follow-up, and then we will conclude the meeting. Honorable Billy, over to you.
Thank you, Chair. So just a quick follow-up, because I don't think this question was answered, directed to the Human Rights Commission. The question is, did the Commission consider any litigation to test the constitutionality of whether the insolvency law, adequately protects the rights of workers? I think there was a concession that perhaps it's not sufficient, not just for the SOEs. Maybe just is there any recommended legislation that the Commission is intending to put forward to the liquidator, Chair? I hear the logic behind the complexities that exist in terms of pursuing any recovery action against former directors. I think while it might be costly, it is also something that has got to be done, because it forms part of consequence management. Because we are going to get other directors being as clumsy with these state-owned entities, knowing full well that it becomes costly to pursue them. So I think beyond the monetary complexities that might exist there, I think in terms of logic and the principle, and more importantly, in terms of consequence management, it is proper, it is correct to set an example, to pursue directors and to make sure that they are held liable So I would suggest, Chairperson, that for this committee to be able to make a conclusive or to assist this process of fact-finding, that report that speaks to pursuing of directors, that it also forms part of what we need to look at so that we are able to make proper findings on this matter. So I would suggest through you, Chair, that we also. Thank you.
Thank you, Honorable Billy. I understand that you are in a difficult area in terms of network. There were parts where you went silent, but I think the member got hold of what your input is, as well as Mr. Ngiamaga was saying in terms of that. And I think maybe as moving forward, I'm just a little bit disappointed in terms of those attempts, and Membeki, you've stressed about it. Even when I look at the presentations, attempts to mediate outside of the legal prescripts. Can you mute your phone, iPhone? So there were attempts to say, let us try to resolve the issue outside of those legal prescripts, but those attempts feel that they did not succeed. And for me, it's a bit of a disappointment because we wouldn't be here we are now. But we really appreciate Membeki for your inputs. From what Honorable Billy was saying and from what I'm saying, I will give you just 2 last bites and then we're gonna wrap this process. If there's anything that specific Honorable Billy was raising and my inputs that I've said, I'm gonna give you the opportunity, Membeki, and then we're gonna close with Ndate Ngiamaga.
So much, Chair. No, in short, we did not consider this aspect of litigating or bringing a constitutional challenge to the Act. I have noted it down, honorable members, and I think we can maybe prepare some opinion on that aspect as the Commission, but for purposes of finalizing this matter, we did not do so. And then in terms of, I think once we've made that, it would also lead to Honorable Billy's second question or a recommendation as to a legislative amendment, which would also prioritize the rights of the employees. So there has been, I have noted that, Chair, down, and I think I will take that as my provision to go back, but we did not consider this aspect. Thank you.
Thank you, Membeki. And Ngiamaga.
Thank you, Chairperson. I hope I didn't miss most of what Honorable Billy was saying, but when it comes to pursuing the directors, Chairperson, the obstacle is the fact that there's not enough funds for us to litigate as the joint liquidators. It would be reckless for us to pursue it purely because there's no funds in the estate to pursue these actions. I agree with Honorable Member Billy around the perceptions. The other alternative option is if there would be an attorney who would volunteer to pursue these matters at risk and indemnify the joint liquidators from any liabilities. It's a balancing act, Chairperson, that we still have to execute our functions within the ambit of the law. And yes, indeed, we need to act in the interest of all creditors, the employees, which we do have a lot of sympathy for what the employees have gone through. However, we can't quantify and say it's going to cost 3 or 6 or 10 million rand to pursue these claims. And we cannot also determine how long that will take. Unfortunately, that's the predicament, Chair, that we found ourselves in. I hope I answer some portion of Mr. Billy's query. Thank you.
No, thank you very much. Thank you very much, members and our stakeholders. We really appreciate it. As this petition, your input has given the committee a clear indication and has opened a lot of those gaps that were closed in terms of the issue of this petition. You would, just for information, the process will then be for us as a committee to deliberate and then develop a report. It will be tabled in the House, in the NCOP, and that will be a report of Parliament. It will contain recommendations and from the deliberation. So those will be, once it's adopted in the House, it then becomes a legal instrument and a legal document of Parliament for those recommendations. So we are taking note of all the inputs that we've made from the business practitioners, from the Human Rights Commission, from the liquidators, as well as the initial input from the petitioner. And we will be able to develop a comprehensive report, and then we will be able to have a way forward from there. But thank you very much, Mayor Mbeki, and Tate Terablanche and Combo, as well as Tate Njasana for those inputs. Honorable members, we are 30 minutes before our time that we've been allocated. I want to really appreciate your participation in this meeting of the committee today. And I hope we're going to see each other later this week when we're doing another matter and doing another work. And with those words, I want to thank you, and as well as to the petitioner and to the employees, the former employees. We are really taking this matter to heart, and due communication will go out in terms of our work. I want to thank Kiza for the support, Mayor Nwala, Mr. Jabulani Majozi. I see you're on board from PCS. Thank you, our support staff. Ms. Fakir, thank you very much. I really appreciate the support. We know that you started with a glitch this morning, but it goes with these issues of technology. And with those words, honorable members, this meeting stands adjourned. Thank you very much.
You forgot Gershwin, Danko.
Thank you, Chair. Thank you, Gershwin.
Thank you, Chair. Bye. Chairperson Ubuela, Secretary.
Thank you, sir. We adjourn till tomorrow.
Yes, tomorrow is security, and then we'll see each other again on Friday in Gauteng.
Oh. Yeah, oh.
Ik zal nou gaan koop.